Are live.
All right, welcome back to the House Judiciary Committee this Wednesday morning, April 16th. And we're going to turn our attention to S28. Before we get started, really quickly, want to kind of set the stage a little bit. So S28 is passed out of healthcare last Friday. It was on Node's calendar yesterday, but there are definitely four sections that we need to look at. Section 1, 5, 6, and 13 is my understanding. And we're going to have some witnesses this morning. We're going to see, after we've heard the witnesses today, what our next step is. The step could be that we'll take a straw poll on those sections. Or if we feel there's a need for amendment, we will see who wants to join such an amendment. Or the last possibility is if we really feel there's additional witnesses that we need to hear from, we will do one of two things. We'll either have the bill postponed until we've done that, or we'll take possession. So that's kind of the setup as far as just process wise.
Question: has an amendment been drafted already?
No, there's no amendment. No,
no amendment. You're just saying that's one of the.
I'm just saying one of the possible.
Okay,
right.
Great.
So depending on what we hear from the witnesses. Because this is really, some of these things that are in here, particularly in section 13, are things that we need to be comfortable with. That's that kind of background, but I'll turn it over to Jen. She can give background of this bill more generally. This is related to the SHIELD bill that we passed last biennium, but with that, turn it over to you.
Good morning, Jen Carby from the Office of Legislative Counsel, and I'm also joined by Michelle, who you all know. And this is S28, an act relating to access to certain legally protected healthcare services. This does make some updates to one of the SHIELD bill, well, sort of both of the SHIELD bills that were passed a few years ago around legally protected healthcare activity, which is a term defined in statute. And you'll see we're making an amendment to it in section 1. But legally protected healthcare activity is the term in statute that describes reproductive healthcare services and gender affirming healthcare services. So we put those together in the definition of legally protected healthcare activity so that it's a shorter term to use throughout the statutes. And so there are a number of sections in this bill that are not, I think, what the committee is looking at, but I've been asked to focus on the ones that are in the Judiciary Committee purview, at least in part, and that is sections, as the chair said, sections 1, 5, 6, and 13. Am I right in thinking you are not put the language up on the screen, committee?
Yeah, go ahead and put the language up.
Want me to put the language up?
Well, she asked me and I said, no, I don't ever do that.
We all have it.
We all have it.
Okay.
No, we all have it.
At least different. So section 1 amends the existing definition of legally protected healthcare activity to add that the protections applicable to persons who engage in legally protected healthcare activity shall also apply to a person who has previously undertaken one or more acts or omissions while in another U.S. jurisdiction to aid or encourage or attempt to aid or encourage any person in the exercise and enjoyment or attempted exercise and enjoyment of rights to reproductive health care services or gender affirming healthcare services. And a lot of that is just picking up language that is in this definition already in the earlier parts. That would have been protected by this state if they had been undertaken in this state, provided that the acts or omissions were permissible under the laws of the jurisdiction in which the person was located at the time they were undertaken.
So this is kind of the correct version.
Yeah, this is.
3.4.
Section
4.
So.
Amendment, that's what's on the.
Maybe I will put it.
So trying to find this language. Let's put it online. Let's put it online.
Okay.
Yeah, sorry that we have the wrong version. I apologize for that.
So not look.
Good, Morris, more.
Committee
Yeah,
webpage.
we'll see what we got from the Senate now. Then we'll.
Oh,
Yes,
this is
it has to be- it's passed by Senate. Yes, it is a strike. The House Healthcare Committee amendment is a strike all amendment.
It's draft number 3.4.
It is draft number 3.4. And then join your Zoom and then we'll put the language up on the screen.
There is an amendment.
There's a strike. Yes, I didn't realize you.
Okay, so
yes,
does that
there's-
House Healthcare? Okay.
Yes.
Yes.
Thank you very much. There's.
It's like, I was just told that there wasn't.
Yeah, so yeah, nothing new from this committee or since House Healthcare
Right, but there is an
passed
amendment.
theirs,
that we're
but there is an amendment that is
House healthcare.
completely different than the Senate has been.
And
But
that is what is on the calendar today.
Jen, you ready to go? Yeah, I'll get this.
Thank you. Yes, I am just pulling up a version to put up on the screens. Let's get to my this healthcare community page.
I apologize that I did not direct link to the appropriate version.
Is it 3.4?
324, it's the version that stands out.
Report of the committee.
Report of the committee, yeah.
Report of the committee of health. Also go to today's calendar.
Yes, and it goes on to the calendar. All right, so I will put this language up on the screen and we will revisit section 1.
Also, just Nate did provide everybody with a copy of the current statute for the definition of legally protected healthcare, because the amendment, lots of times we won't reproduce all of the existing law. So if you need to refer back to that as to what the existing definition.
It's a great point.
You have a copy of that.
Yes, so this section 1 amendment just slots in as a new subdivision B4, and there's an existing B1, 2, and 3.
Okay.
All right, so now that we're looking at the same thing, the protections applicable to persons who engage in legally protected healthcare activity shall also apply to a person who has previously undertaken one or more acts or omissions while in another U.S. jurisdiction to aid or encourage or attempt to aid or encourage any person in the exercise and enjoyment or attempted exercise and enjoyment of rights to reproductive healthcare services or gender-affirming healthcare services that would have been protected by this state if they had been undertaken in this state, provided that the acts or omissions were permissible under the laws of the jurisdiction in which the person was located at the time they were undertaken. So this is providing some reciprocity for providers from states that also have protections for legally protected healthcare activity if they are in Vermont.
Oh, Zach.
Exercise and enjoyment. Is that typical language?
In the context of rights, yes.
Enjoyment is.
Yes.
And can you give an example of what some of this healthcare activity might be?
So the legally protected healthcare activity is reproductive healthcare services or gender affirming healthcare services. So helping somebody to access or providing those services.
And that could be like transitioning, for example, like
It could be, right, it could be medication, it could be medical services.
and only assuming if it's legal in the state from which they traveled from.
Right. So I think, they're the example that I've heard, because there is a provider in New York where this is legal. If that provider were to come to Vermont, where it is also legal, if there were efforts to remove that physician from this state, which in New York law says we will not cooperate with that. Vermont would not either. Vermont would also apply that protection. Anything you want to add on that?
Just the kind of the underlying what we're talking about. So there were 2 acts that were adopted in 2013, Act 13 and Act
2023.
2023.
It's okay.
Sorry. Act 13 and Act 14. And one was focused more on the regulation of the medical kind of profession around legally protected healthcare. And then the other one was around criminal and civil procedures related to legally protected healthcare. And so that bill was in this particular committee, and the other one spent most of its time in the healthcare committees, but they worked together in concert. And essentially it was that if you read those 2 bills together, so it adopted the definition of legally protected healthcare that you have in Title I, Section 150. And there are several places in the acts that state that it's the public policy of Vermont to protect folks who are either providing legally protected healthcare, seeking legally protected healthcare, or facilitating someone obtaining that healthcare. And so it's the stated policy. And then there are a number of provisions through those 2 acts that tweak laws around looking at, issues around, states not going to expend resources. Let's say if there is a litigation that's filed in Texas against a Vermont provider, right? And it's in conflict with Vermont state policy, and that provider was providing services that are protected in Vermont, and they're doing it in accordance with their license in Vermont. That we're not going to cooperate with, let's say, Texas going after that provider in Vermont, essentially. And so this is kind of just building on that and tweaking in a few different places. And because there are a number of states that have either identical or very similar laws to what Vermont has, as long as those laws are the same and those protections are afforded to that other, let's say, provider in that state, and they were acting legally in that state, that if they leave that jurisdiction and they come into Vermont, right now, they wouldn't have the protections, obviously, because you can only control what, was within your state borders, is that Vermont would then be affording them that same protection as if they were in Vermont at the time that they had engaged in conduct.
What if somebody from Vermont goes the other way?
No other state has the reciprocity currently.
Wouldn't be surprised if there was more, if Vermont kind of starts the trend. But yes, as Michelle said, we can only control what happens in our border. So if a Vermont provider leaves the state, we don't have control.
Do that. I just didn't know if somebody had already.
No one has done this yet.
Other questions on this particular section for legislative council?
All right, we will go to section 5, which is on page 10. So I'll scroll you through page 10. No, so it'll be up on the screen. Section 5 amends an existing provision that was enacted in one of those 2023 shield bills, 12 VSA section 7306, which is on non-cooperation. And some of this is just changing language a little bit to be clear when we're talking about an individual versus an entity, because the definition of person in Title I includes both individuals and entities. So under existing law, no public agency or employee, appointee, officer or official, or any other, and this would just change person to individual, acting on behalf of a public agency, may knowingly provide any information or expend or use time, money, facilities, property, equipment, personnel, or other resources in furtherance of any interstate, and then this is the substantive change, or federal, this would add, investigation or proceeding, seeking to impose civil or criminal liability upon an individual or entity for the provision, seeking, or receipt of, or inquiring about legally protected healthcare activity that is legal in this state, or assisting any, and again, changing from person to individual or entity, providing, seeking, receiving, or responding to an inquiry about legally protected healthcare activity that is legal in the state. So again, the changes in this part, really, other than the terminology change from person to individual, so we're clear when we're saying a natural person versus an entity, is to add, relates to both interstate and federal investigations or proceedings. And there are certain exceptions that get amended here as well.
Yeah, and I think I understand what the spirit of and the intent of what this section is looking to accomplish. In layman's term, can you describe what this is looking to do?
Yes, or do you want to, because it was your original section?
Sure. So, as originally drafted at the time when the legislature was considering these bills, and it was all focused on interstate interaction, right? And so essentially, it's saying that, it's the public policy of Vermont to ensure legally protected healthcare. And so there's a directive that we're not to use state resources if there's a piece of litigation coming from another state regarding legally protected healthcare. And then there's the addition of the federal here. So again, it would just be that you can't use, time, money, resources, facilities, things like that, if there was a federal investigation that related to abusive litigation concerning legally protected healthcare. So it's about the state. It's kind of saying, we can't control what the feds do, right? So feds can do their thing. We've only got control over what Vermont can choose to do. And the state is saying that essentially it's the policy that we're not going to assist the feds with regard to any federal investigation looking to assign liability
The exceptions are important
Right.
for you to have in the context too. So
Yep.
in the existing law, it says this section shall not apply to any investigation or proceeding where the conduct subject to potential liability under the investigation or proceeding would be subject to liability under the laws of this state if committed in this state. So, anything that would not be legal here would not fall under this non-cooperation piece. This is amending an existing provision, and this is subdivision 2, currently says any action taken by the judicial branch in judicial proceedings. In conversations with Michelle and others is a little unclear. So we updated the language, but also added the federal court. So any order issued by a Vermont state court or a federal court. If Vermont is ordered by a state or federal court to devote resources and cooperate, then that cooperation must occur. And then finally, any a public agency or employee, appointee, officer or official, or any other individual acting on behalf of a public agency, and that's inserted to be consistent with the language in the lead-in, who in the course of normal business is responding to a warrant or extradition demand on the good faith belief that the warrant or demand is valid in the state.
Correct. Do any other states have language like this? Who?
I'd have to go and check.
I would love to see that list.
So also,
Oh, go ahead. If there was a follow-up to that question, because I have another one as well.
you do yours and then I'll see whether.
And I'm just wondering, say the Attorney General Bondi, starts filing litigation suits against the state of Vermont. I'm wondering, what kind of culpability we would have for non-cooperation, either by instance of the governor or human services. I'm just wondering, what the dominoes could look like with the current administration if we don't cooperate.
I mean, I think the issue is it's hard to kind of know right now what that might look like. I think in terms of if there, so the reason why there's the exemption for the court orders is because if you're looking at full faith and credit clause, which requires the states to generally recognize the statutes and laws in other states. However, there's some wiggle room there around if you have a public policy exception, right? So if your policy is diametrically opposed to this other state, you can kind of reject that other state. So that's what a lot of the shield law stuff is built on. The exemption with the federal court orders and the state court orders is because you don't have that leeway when it comes to legal judgments. There's not the same, there's a very narrow basis to be able to say, to challenge the jurisdiction of the federal court. So with regard to what action the feds might take, if there's a federal law that the Attorney General of the United States is enforcing against Vermont here, and we don't know what that might possibly be, there's supremacy clause, right? So, under the US Constitution, if there is a federal law and the feds have clear jurisdiction to Congress to adopt that law and the administration to enforce that law, and it's in direct conflict with state law, then supremacy clause wins. So in those particular cases. So I think right now it's all speculative. But I think, when you're talking about all of these things, you have to keep in mind that, one, we have to comply with judicial orders. And two, there's always a supremacy clause. So if the US government said, here's a controlling federal law here and the state law is in conflict, then federal law is gonna control. But in terms of what that would be, I don't know.
Yeah, no, I agree with that. I think we're in the early innings of this, right? Early 4 months of
That's
the
right.
administration. So
I think the idea here is to put the state in the best position possible to defend the laws that are on our books.
Right. It's really focused on, this is Vermont's policy. Vermont has decided to protect this type of provision of healthcare and obtaining this healthcare. And so when you're in the borders of Vermont, this is protected to the extent that the state can continue to provide those protections. If there is an argument that federal law somehow requires either disclosure of information or cooperation in an federal investigation or anything like that, then that will have to be taken on a case-by-case basis as to the authority of the feds to be able to assert that right.
Is this kind of a small step toward autonomy for Vermont? A small step, but it can't take a big step because there's still the federal laws that could have jurisdiction.
I don't think it's autonomy. I mean, healthcare is generally a subject in medical services that is left to the states. So
Okay.
I think for Vermont to assert a position in the area of healthcare and health provision of healthcare services is not unusual.
All right, anything else on section 5 from anybody for the legislative council? Moving to section
Section 6. Section 6, we are on page 11. And this is amending a statute on prohibiting disclosure in many cases of protected health information. And this is kind of growing out of and being more protective than HIPAA. So a lot of the definitions that are in this section in the existing law refer to HIPAA. A covered entity is an entity that is covered by requirements of HIPAA. HIPAA is the Health Insurance Portability and Accountability Act of 1996, and uses existing definitions from HIPAA and from the definition in Title I of legally protected healthcare activity. And then there's the use of the term telehealth, so that is defined as in our statutes as well. So in general, there's a requirement from existing law that a covered entity or business associate not disclose protected health information unless the disclosure is permitted under HIPAA. Also in existing law, there are some provisions where even if HIPAA would allow disclosure, Vermont law says the disclosure is not permitted. So HIPAA is considered a floor, not a ceiling. States are allowed to be more protective than what is in the federal HIPAA law. So this says, notwithstanding any provision of subsection B, notwithstanding the part where we said you can only disclose if it's consistent with HIPAA, in order to protect patients and providers who engage in legally protected healthcare activity, and except as set forth in subdivision 2, where we're going to have some carve-outs, a covered entity or business associate shall not disclose protected health information. And then this uses kind of the HIPAA standard of that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity. So shall not disclose to any government entity other than the state of Vermont or its political subdivisions or instrumentalities if the covered entity or business associate has reason to believe that the information will be used, one, to conduct a criminal, civil, administrative, or professional disciplinary investigation into any individual for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity, or to impose criminal, civil, or administrative liability or professional disciplinary action on any individual for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity. So to conduct an investigation or impose liability, or to identify any individual for any of those activities. Or, and this is existing language, for use in a civil or criminal action, a proceeding preliminary to a civil or criminal action, or a probate, legislative, or administrative proceeding. And now we've kind of changed the structure here. So under existing law, it says unless, and it lists some things. This just creates its own subdivision 2 for the carve-outs.
Before you go on.
Yes.
It seems to be very, very vague to me what I'm reading, that I would need some time to digest a little bit more of what we're talking about. All these, just general terms. I have bells and whistles going off from federal law and state law, the Title 18, 42 series. Like we're gonna spend a couple weeks rewriting any of that. I don't know. When we start talking about prescriptions, I don't, let alone know anything about what medical licenses and how they're regulated, state and federally. I have no idea.
So the medical
I'm
license,
lost.
yeah. Yeah, the medical licenses and such, it's not really our subject matter.
Right, but what about the drug? Are there drugs involved in that?
When we, so I'm not, what do you mean by, are there drugs involved?
Prescribed drugs?
That is part of legally protected healthcare activity.
Those are also federally regulated, and the people that distribute those are regulated federally, and they could lose their license if they do not follow the federal regulation.
So, I mean, those,
I'm just asking questions here, because I just got, it seems very vague, and I got all kinds of alarms going on.
so most of this bill doesn't do anything specifically involving regulation of prescription drugs. There is one piece on the pharmacy dispensing that we'll be looking at, and that's section 13, but that really has to do with what information is on the label, and it has it complies with what is required under federal law.
And it's also in our statute as well, in 4200.
We don't have
I
4200. I'm not
Sure does.
Oh. in the regulated drug.
Yes.
Yes, but I don't believe it specifies what has to be on the,
I'm almost certain.
I'm sorry, what's?
So I'm not following,
Title
I'm not
18.
following you on what the question
Under
is.
health.
We're talking about cannabis, because that's not
yeah, we do have regulated drugs.
Right,
right, yeah.
and there's 4213. There's authorized sale, identification, labels.
Okay. And does it require that the prescriber's name be on the container when it's taken out of the,
And the receiver.
so, but this is only for regulated drugs. Regulated drugs fall under controlled substances, and the provision in section 13 excludes controlled substances. Because that is,
Have we jumped ahead?
Yeah,
I just feel like we should stay
Yeah,
where
no,
we're
I
at.
was just gonna, yes, I mean, is this the issue?
Well, it seems like maybe there's some of this embedded in 5, and then maybe there's some later on in, I don't know, but.
See. So can you back up and explain section 6 a little bit more as far as what it's getting at, as far as the protected health information?
sure, this is around the types of protected health information that covered entities, which are sort of generally providers of healthcare services, who bill for their services, can be permitted or required to disclose,
Such as?
such as the name of a patient who is receiving certain types of care.
Okay.
And this is protected health information that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity.
So I just have a question on the term legally provided and whether legally protected versus legally provided. And I'm wondering if there's a distinction there, or if like some kind of language should be modified to include that these services are being legally provided to patients.
I'm not sure I mean, this is,
Because I get that the services might be legally protected in the state or in other, if there's reciprocity with other states. But my question is, and my concern is, whether the services or the medication is legally provided to those patients.
that is generally a licensure issue.
Right.
So providers have to be acting within the scope of their license in order to be providing any healthcare activities.
But I think you would agree that there probably are some providers that are not acting in those legal bounds.
I have no opinion on that.
Right.
I don't
Well,
work for the-
that's a reality, but it's something that I think that we should just be mindful of as well.
What are you talking about?
Whether medications being prescribed illegally or provided under the table to patients.
In your healthcare jurisdiction.
Yeah, I mean, so section 6, the more I'm looking at it, I'm not sure where the subject matter intersects with us, because it's seeming more, this is just an initial quick look at it. If we could, I mean, it's a HIPAA issue mainly, and this is not a HIPAA committee. I think what caught my eye initially was the sections talking about conducting criminal, civil, administrative, professional, just, once I see the word criminal in infractions, I think that we need to look at it. But I need to kind of narrow kind of what we're looking at rather than starting to dig deep into HIPAA, because that's not really us.
Yeah, so largely what this section is doing is saying there are certain things, certain types of disclosures that HIPAA may permit, but Vermont law does not. And so under federal law, as I said, HIPAA is a floor, not a ceiling. States can be more protective. So this is putting in provisions that allow covered entities and their business associates to decline to disclose protected health information that is identifiable or susceptible to re-identification and is related to legally protected healthcare activity. If it's going to be used outside of the state for a criminal, civil, administrative, or professional disciplinary investigation, or to impose liability for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity that is legal in this state.
So can I add something, Jen, that
Sure.
might help? So this would be when you talk about like in the criminal context would be that if someone was a Texas resident and they left Texas, they came to Vermont, they to obtain legally protected healthcare in Vermont, they received that medical care from a licensed practitioner here, and they provided that care in the scope of their license and in accordance with state law. But Texas decided to charge that Vermont provider with some violation of Texas law. This is saying that, you know, you wouldn't have to give that information out, and that information wouldn't be available with regard to that criminal prosecution in Texas.
Which is information that under HIPAA could be provided, but we're saying because we.
Right, in certain circumstances, we're saying that you don't provide it in these particular contexts. But again, HIPAA is the floor, compliance with HIPAA, federal law controls there, but the state still has some room to operate.
If it is more protective of individuals.
Ian.
And there are several exceptions as well.
I'm just curious if, okay, so yeah, information that HIPAA protects, then there's some additional information. We're saying that this covers that additional information in these specific particular instances. Is there like a carve out for negligence? So I'm thinking about, and maybe it's just, I don't understand this quite yet because I'm reading it quickly. If you had a healthcare provider providing a service in Vermont to a Vermonter, but there's that individual's injured because of negligence from.
That's not covered by legally protected healthcare. If it's in by.
Oh, there, that's what
That's that, then that's the underlying
Right.
law.
Okay, and we don't have, which I'm not looking at. but
Right, so the
legally
foundational
there it
law
is.
is
That's what I
that
need here.
if you
Okay.
provide that care contrary to statute, outside the scope of your practice, or basically if it would be an issue here in Vermont.
Yep, no longer legally protected.
It's not legally protected.
That's what I need. Thank you. Perfect. Thank you.
Right, if you run through those.
All right, so the exception says notwithstanding that prohibition on disclosure, a covered entity or business associate may disclose that information if it meets one or more of the following conditions. It is authorized, the disclosure is authorized by the patient or their representative, legal representative. This omits an automatic disclosure if it is specifically required by federal law, Vermont law, or rules adopted by the Vermont Supreme Court. But it does maintain the disclosure ordered by a court of competent jurisdiction under federal law, Vermont law, or rules adopted by the Vermont Supreme Court. And under existing law, an order compelling disclosure under this subdivision must include the court's determination under current law that good cause exists to require disclosure. This language is amended to say the information will not be used to impose criminal, civil, or administrative liability or professional disciplinary action on any individual based solely on the fact that they were involved. Just say it's shorthand in a legally protected healthcare activity. The changes in subdivision C are really clarifying some terminology, but if this is about disclosures made to a covered entity's business associate and will be used to defend that covered entity or business associate against a claim that has or they have a reasonable belief will be made against them. And then D and E have not changed. This is disclosures to Vermont's Board of Medical Practice or Office of Professional Regulation. in connection with a bona fide investigation about whether somebody who was engaged in unauthorized practice in the state. E has not changed either. This is a disclosure to the Department of Health or the Department of Disabilities, Aging and Independent Living, or both, in connection with the bona fide investigation of a licensed healthcare facility in Vermont. F is new. That says, subject to the non-cooperation section, the disclosure is required in the ordinary course of business of Vermont's Medicaid program. So if that's required in order to allow the regular operation of the Medicaid program, it can be disclosed. And then finally, D is providing some protections to a covered entity or business associate. They will not be subject to any civil, criminal, or administrative liability or professional disciplinary action for refusing to disclose protected health information that is identifiable or susceptible to re-identification and related to a legally protected healthcare activity. So basically, if they are following what is permitted in subsection C, they will not be subject to liability for following that law.
Okay. So if I'm understanding this right, I mean, has the word federal been in this language before with this, with the original bill that we're,
In some places, yes, and in some places it's new.
so this really, in my way of thinking, we're just, now the state of Vermont is doing everything possible to protect everybody that wants to do this from the feds coming in here and doing what they think is right, for lack of better words, or holding accountable.
So it doesn't provide protections against federal court orders. But yes, it does strengthen protections or attempt to strengthen protections against action by the federal government.
So is it fair to say that more than likely there's going to be even more lawsuits coming by doing this between the feds and the state of Vermont?
I don't think we can, I don't have a take on what's likely or what's not likely. I don't believe we're subject to federal lawsuit.
Right, I mean, Vermont
That's what
is,
our government
what
does right
you've
now.
done in the underlying legislation and in this as well, is regulate what's within the purview of Vermont to regulate. That's only what you can do. If there's a conflict with federal law and federal law controls, then federal law controls.
But whether anybody wants to say it or not, this is being strengthened now because of the current administration that's running this country. Correct.
They didn't sponsor the bill, so that would be a
Okay, well, we can play word games all day if you want to, and I'd be more than happy to go on 24 hours like other people do. But we're opening ourselves up for serious lawsuits. And also, these are not even Vermont residents. These are residents that are coming from out of state to come to Vermont to have this procedure done. And then we're being held responsible for and also protecting all of their identity. And we're putting all of Vermont at a certain amount of risk. Am I wrong?
I don't think those, you can ask that of other witnesses, that's not questions really for legislative council.
Aren't they lawyers?
Right, but that's not what those questions are pushing. Do you have any other questions for them on this though?
Well, I don't know if I can ask them because they won't be politically correct. So I'll keep
Well,
my
no,
mouth
you can-
shut.
yes, well, we have other witnesses that can ask questions on Zach.
I have a clarifying question on the healthcare amendment, the strike all. Was this a committee amendment or was it offered by individuals on the healthcare committee?
It's a committee. I mean, the bill was referred to the committee. The committee had possession of it and did a strike all amendment as a committee.
And that was, this amendment was supported unanimously?
It was not.
Okay.
No, I believe that, oh,
The amendment was, the bill was not. The
So-
amendment on the straw poll was 11-0-0, the bill was 8-3.
okay.
Could you identify yourself for the record as well?
Daisy Rebecca, ranking member healthcare.
So I want to make sure I'm completely clear on that, because my understanding is the committee report on draft number 3.4. I just want to make sure that we're talking the same thing. If there's another amendment out there, or my understanding was that it was 8-3, I thought.
Yes, when it came out of our committee.
So what was unanimous? I guess I'm confused.
Yeah.
I think what you're, if I may, I think what you're saying is that there was a voting committee to put forward the amendment, right? And the language and the agreed upon language in the amendment for House Healthcare Committee. Then there's a separate vote to vote the bill out as amended recommended by House Healthcare Committee, and that vote was 8-3.
Correct.
So yeah, what we're looking at here is voted.
And that is, so this is the official amendment being, and the report of the Committee on Healthcare that is currently on the calendar for the House right now that you're taking a look at.
Right, and that was 8-3, just to be clear. I mean, often in here, for the amendment to get to the bill, even if somebody votes against the bill, somebody will just vote yes just for the amendment, move it along, and then we vote on the overall thing, and then that's when we take the roll and where that can happen. Are we all clear?
Yeah.
Okay. All right, good.
Okay, do you want to look at section 13?
Well, let me just make sure. Any other questions for legislative council on section 6? All right, let's go on to 13.
So can I don't want to derail things, but I do just want to make a clarifying point to Tom's raising the issue around chapter 84 and title 18. So that has to do with regulated drugs.
Right.
Regulated drug is
Where are the difference?
Okay.
But I see under prescription.
It might help with us.
Right.
Okay,
We'll look at the language and then you can look at the language.
Okay, go ahead.
So, and I
Thank you.
realized I had not put the language back up, so I'll put the language up. We're looking at section 13 now, and this is in Title 26. It is adding a new section in the pharmacy statutes for confidentiality of prescriber and pharmacist information on medications for legally protected healthcare activity. It starts out with definitions. First, definitions of gender affirming healthcare services and reproductive healthcare.
Apologize.
Definitions of gender affirming healthcare services and reproductive healthcare services have the same meaning as in 1 VSA section 150, which is in that definition of legally protected healthcare activity. And a non-controlled medication means a medication that is not a controlled substance under federal law. So that is largely taking everything out of the scope of chapter 18 VSA chapter 42.
correct.
So then in subsection B, subdivision B1, upon the request of a prescribing practitioner and to the extent not expressly required under federal law, a pharmacist or other licensed member of the pharmacy staff shall redact or otherwise remove the practitioner's name or initials from a fulfilled prescription for a non-controlled medication for gender affirming healthcare services or reproductive healthcare services and from any accompanying printed materials. Subdivision 2 allows has similar language for pharmacists. So the pharmacist may, or upon the pharmacist's request, another licensed member of their staff shall redact or otherwise remove the pharmacist's name or initials from a fulfilled prescription for a non-controlled medication for gender affirming healthcare services or reproductive healthcare services and from any accompanying printed materials. And 3, if a prescribing practitioner is dispensing medication directly to patients, which is within the scope of practice of some practitioners, for gender affirming healthcare services or reproductive healthcare services or both, the practitioner in this case may also redact or otherwise remove their own name or initials from the fulfilled prescription for a non-controlled medication for these services and any accompanying printed materials. And I believe here's the piece that brings this, particularly in this committee, nothing in this chapter or the rules, not this one, next one, or the rules governing the pharmacy profession shall be construed to require a pharmacist or other licensed member of a pharmacy staff to list the prescribing practitioner's or pharmacist's name on a fulfilled prescription for a non-controlled medication for these services. Now we're in the part that brings it here. A pharmacist or other licensed member of a pharmacy staff shall be immune from civil, administrative, and criminal liability for failing to redact or remove the name of a prescriber or pharmacist when requested to do so pursuant to subdivision B1 or 2, provided, however, that this immunity shall not apply to gross negligence, recklessness, or intentional misconduct by a pharmacist or other licensed member of the pharmacy staff.
Before I go to Zach, I just want to clarify one thing as well. What is a fulfilled prescription?
Means it has been, it's the medication itself. So it's
Pill bottle?
the pill bottle or the package, and the accompanying printed materials might be the paperwork stapled to the front
Okay, all right.
of the package.
Zach?
Thank you, Chair. On subsection D,
Yes.
do we offer those kind of protections to any other profession in the state?
Yes.
I mean, this is a standard immunity.
Come up with a list of things.
I love that. So states with reciprocity that are using the same language, subsection D, I'd love to know the other professions that we're protecting.
This is in a very specific context.
I understand.
Are you talking about other states that have this exact thing, or you're just
No,
talking
no,
in
I'm talking
general
about
where we provide?
Language that we borrowed for this legislation in the earlier sections that, I mean, we can. Excuse me.
I didn't understand. My apologies.
Okay. We were talking earlier about language in the previous sections where other states have mirrored that language.
Okay.
We're talking about reciprocity and.
You're just recapping your earlier
Yeah,
request.
exactly. I'm just recapping my earlier.
But
request.
do
Earlier
other
request.
states have this
No, I
protection
think,
on?
no.
I'm not
the
focused
other
on that. What I'm focused on,
professions in Vermont have immunity language, like,
that's a separate ask, correct?
right.
Yeah, and so that's what I'm getting at here. Because I would like to understand what other professions the state of Vermont is providing these protections for.
Okay.
Are you
Because
talking?
this seems extraordinary to me.
So to be clear, the immunity is for failing to redact or remove the name of a prescriber when they've been asked to. That is all the immunity is for. Somebody was
But I-
asked to remove a name and they did not.
I understand,
Okay.
Jen, but the point that I'm making is I just want to understand where other professions that we provide this similar type of immunity to. Because it seems extraordinary. Even if it's something as innocuous as failing to remove something from a bottle, it seems like an extraordinary that we're taking.
To provide.
Yeah, big time.
Tom and then Angela.
Sorry, I'm just trying to understand it. I know what a regulated drug is in the state of Vermont. Generally, it's something like marijuana or cocaine or whatever by definition. But I go to prescription, our definition of prescription makes it a little bit more confusing. And federal law, that's just, you can read all that. When I read our definition of prescription, it says all about the labeling. So if I think about prescription, when I go to the pharmacy and I get, say, an antibiotic, is that that's a prescribed medication?
Yes, but it is not a regulated drug
It's not
under,
regulated. Is it controlled?
no, it's not a controlled substance.
So why do I have to have somebody like that give it to me when I could just buy it?
So it is not an over-the-counter drug, but there's a difference between being what Vermont defines as a regulated drug, which is similar but not identical to a federal controlled substance, which is on Schedules 2 through 5 of the Federal Controlled Substances Act.
Not really.
Well, but you got your question, right? Angela.
I was not raising my hand, but I will ask, I just want to be clear, check my understanding that D on page 26, if anything, actually weakens the requirements. And weaken might be a strong word. It softens the requirements on pharmacists and prescribers in a way, right?
It provides some latitude for ordinary negligence in failing to redact or remove.
Right. Or like a learning curve or time to adoption and things like that.
Right, it's my understanding, and I think you're going to hear from the pharmacists as well, but that there are a lot of different a lot of different interfaces from, as the information goes from the prescriber's office to the pharmacy, and that there's an opportunity for information to get missed. That might be information like a redaction of a name. And so the pharmacists had raised concern about their own liability if they missed the request.
Thank you.
But I think especially as it's new and, these are not medications, some of these may not be medications that they fill frequently.
So just to walk through this, I want to make sure. So they get the prescription from the doctor. It has the doctor's name on it, has the pharmacist, gets that prescription. And when they're filling out whatever the label for that packaging, they don't include the pharmacist's name or the doctor's name. That's all that this is doing? Or maybe other information that's
yes.
included in
No,
the
I think
pack.
the language that came over from the Senate was literally like, don't put it on there. I believe just put the facility name, and there was testimony from the pharmacist that they often can't omit the name from the label, but in this case, they might have to cut it out or,
Or
park
sharp or
upstairs without
whatever.
Sharpie, exactly.
But that's the point, is it doesn't have what the patient receives, doesn't have the pharmacist or doctor's name, but the prescription had the doctor's name on it.
Right, and they're still in the records.
And it's still in the records
pharmacy
and all that.
records,
So it's
yes.
really just on that, whatever that medicine that.
Whatever is traveling out in the world.
Right, so if it's not labeled, if somebody messes up and says, oh, I put the doctor's name on, what is the liability that it sounds like it's that doctor that would buy and sue the pharmacist for not having the name on. What is the big risk that this immunity is protecting? And maybe we have a witness from.
Yeah, I would let the pharmacist tell you what their concerns were.
Okay, yeah, because also it's like, what possible criminal liability are we talking about if you have an
Yes.
answer on that?
Right, criminal seems less likely than civil.
Yeah, well, yeah. It's like, so here's the issue with having criminal liability in there at all, is that the immunity shall not apply. You need reckless or intentional misconduct to become a crime. There are a couple of crimes out there that mere negligence, but that's very much the exception. And I just don't see how criminal liability applies at all. I could see the doctor suing the pharmacist for having their name on, but it just, but we'll hear from
Yeah, and it may be appropriate to take it out. I think, when I had sought some guidance on immunity language, that is what I've provided. But if it's not appropriate, I'm certainly amenable to hearing an amendment from the committee or individual members to remove that piece.
Have we ever, with the pharmacist, with the pharmacist, as heavily regulated as they are they, does that vary from state to state, or is that federally regulated?
Requirements to be a pharmacist, or it is state.
It is state to state laws?
I believe so. There may be some, I would assume there are best practices across all, but they're licensed by our Office of Professional Regulation, and they're created. Their authority is created by Vermont statute. There are certain requirements they would have to comply with that are federal, but the regulation of the profession itself is up to the states.
So have we ever gone down this road with the with pharmacists before this bill?
What, allowing redaction? Allowing redaction?
Have we ever put the pharmacists, this, in my mind, we're really going down, we're putting the pharmacists at a serious risk. One little screw up and it happens not only in this type of care, but in other types of care where they lose their license, they're sued, they're all kinds of stuff. It seems like this is a real slippery slope to where, for lack of better words, it seems like to me we're creating a black market with protections with everybody at the pharmaceutical level.
Well, this is just about what name of the prescriber and the pharmacist can appear on the bottle that the patient takes home. It's not about what can be prescribed or dispensed. It's not about using the appropriate level of care or practicing within the scope of practice of pharmacy. None of that is changed by this. This is just about removal of a name from a bottle.
But accidents happen, mistakes happen. So then the lawsuits come. And then the other thing is, who's paying for this medication?
The patient or the patient's health coverage.
Health coverage?
It depends it depends whether the person has coverage and what's covered under their plan.
So if it's an out-of-state person that comes to Vermont for this care, are Vermonters on the hook at all for any of this?
No, I can't think of a way they would be. I'll look to some of the providers, but there's,
Unless it becomes a lawsuit and then the state's attorney is in litigation with the feds or whoever, then we're paying for it.
Tom. This Tom and then that Tom. Tom, right?
Nice recover.
Yeah, not that stage that you're.
So just a clarification on redaction on prescriptions. So if it's not a controlled substance, you can redact the information, but if it's controlled, you can't.
yes, the federal law is a little ambiguously written, but suggests that it defines, healthcare committees heard me say this, it defines individual practitioner and institutional practitioner and then requires the name of the practitioner. So when we were looking at maybe just having the facility, there was a question about whether that could be allowed. But yes, federal law appears to require the name of the prescriber to be on the physical prescription container for a controlled substance.
Scheduled drugs.
For the scheduled drugs, exactly. And that is why there's the carve out.
Yeah.
With the additional language as well about unless specifically expressly required under federal law. So if there's a piece we're missing where that changes, it would not be permissible. You want to hear from the,
Yeah, we will in a second, I'm sorry, Daisy, go ahead.
I just wanted to add that I hear the deep concern for this issue and wanted to note that we took testimony from several providers. And it was noted that they get about 2 requests per year, and the pharmacist also noted 2 requests per year for redaction. So this is not something that we expect they would be frequently dealing with.
That would bring up my next point.
Yeah, Tom?
I frequently deal with this. In law enforcement, people steal pill bottles. We find them all the time and they redact them, they peel them, they do all sorts of stuff so that we don't know what's in the bottle. And immediately you assume that, well, it's something they're not supposed to have. And so now you're gonna spend time pulling out physician desk references and things like that, trying to actually identify the substance within the bottle. And that's just, that's why I was always led to believe legally, they have to leave the label on there.
so this is just about the name of the prescriber or the pharmacist that would be removed.
I think sometimes
For
there is a label
non-control.
on there, it's just, not them. So to speak.
Sure. And I'm sure people sometimes
I would be
remove the
curious to
label.
know what some of these drugs are that we're prescribing that you're looking to.
Yes,
Yeah.
witnesses.
Yeah, I'm hoping some of the other witnesses.
Zach, then Karen.
So I guess going back to the redaction concept, if everything's being done legally and above board, I'm curious why we're even talking about redaction in the first place.
So I think I would again defer to the prescribers and your other witnesses to give you the rationale for their request.
Yeah, I mean,
What's the comfort level I would ask of the pharmacist or something?
Yeah,
right.
Get the
You're
pharmacist.
gonna hear, we will be hearing one of those momentarily.
Karen.
I think we're moving towards hearing from witnesses, so I'm just 2 things. One, can you remind us again what our goal is with looking at this? And our jurisdiction of it? Because I feel like it always gets tricky when we have a bill that covers different areas of like,
Right.
what is the area that we're looking at? And specifically for this bill today, what is the action we're moving towards?
Again, to reiterate, I mean, we're gonna look and see if there's, where we are after we've heard from witnesses, if we need to hear from more witnesses. And if there's going to be any amendments from us. And eventually a straw poll on those sections, that we include our subject matter jurisdiction. And so we'll see about the timing on this. If we need more time, we'll get more time to look at it.
And the question I guess I have is, when questions are brought up that are outside our jurisdiction, like I feel it's important to be like, it sounds like that's healthcare and that they've already weighed in and made those decisions. Like, can we have a process in here that we can bring that? Because I feel like it's not helpful for us to use time to discuss things that are not in our jurisdiction. So I just raise that for all of us.
Yeah, no, I agree. It's not always clear, though. I mean, there's a lot of gray areas that we kind of need to understand a little bit about. I don't want to go deep into HIPAA, but I want us to understand enough on HIPAA to understand, that immunity that's at the end, for instance. So it's kind of gray area, but yeah, we'll try to do that. Yeah. Yes.
But what starts in healthcare will eventually, if it goes the wrong way, will eventually end up in judiciary. Because the two judiciary committees are the ones that make the laws, correct?
No, I mean, all.
Or would enforce laws like what's being proposed here.
Not all parts. I mean, there's licensing parts in here. I mean, yeah, we're looking at things in part. I mean, lots of things can end up in court. But so we're looking at some things that could, like the immunity provisions really are the top ones that are really clearly in our subject matter jurisdiction. But so, I mean, it's more of an art than a science as far as figuring out exactly what we're looking at. But so, I mean, for instance, we want to make sure, and I think the discussion about the supremacy clause and how federal law would trump this law, those kind of things are within our jurisdiction to understand that part of it. So that was really in sections 5 and 6, that's one of the more important issues there. And also looking at those immunity provisions as well.
But help me understand, if this is not followed precisely, it becomes judiciary. It ends up in the court system, which is judiciary.
Right.
Am I wrong?
Yeah, no, I think that, the other thing we look at is this going to lead to a big influx of additional cases? That's often the question we can ask Judge Zoning that, so that definitely, that's a frequent reason we bring in the court is to have them weigh in on how this is going to affect their workload and such.
But we're taking this to another level that we really have no idea, like whatever the 2 cases were that I just heard, like in my mind, we're like promoting this, like come to Vermont, we're going to protect you above and beyond other states. Because I keep hearing Texas, we all know Texas, which is a hell of a lot bigger state than Vermont, that Texas this and Texas this, and then the state of Vermont. Right?
So, I mean, the overall intent of the bill is to protect the public policy that this state has implemented, including through the constitutional amendment related to bodily autonomy, as much as we can, given what we understand is happening in other states. That's, as far as I know, there hasn't been litigation related to this in 2 years since it's been passed, is my understanding, at least not in this state. There has been.
Not the aspects we have been talking about.
Right.
Zach.
I just have a comment, I guess, in regards to something that was just said, and it's actually piggybacking on what you just said, Chair, is, while we're only considering sections 1 5, 6, and 13. I do want to say that these sections don't exist in a vacuum, right? And it behooves all of us on the committee as we are litigating on behalf of and creating legislation on behalf of Vermonters to understand the context of how all the other sections interplay with one another. So I think it just is it doesn't really make sense to me to say yes, we are entertaining the other sections, but we have to understand how the bill interplays with itself. 1, 5, 6, 13 are not existing by themselves.
Right, and I think they exist more in the context of the underlying law than some of the other.
Well, that's right.
Which are very different in this.
And that's right. And I haven't heard a single question brought up from anyone in here that isn't relevant to the individual sections. So I just hope that wasn't a play at discrediting some of the line of questioning
No.
by one of the members on the committee, because I don't really think that's appropriate.
Well, I mean, we don't want to go down, and that's why I pulled back as far as it sounded like we were going to start getting deep into HIPAA, which is not.
Right, and which the committee adjusted course.
Yeah. And that's, and I'm just going to watch out for that kind of thing.
Yeah.
That's all.
I just wanted to state that.
Anything else for legislative council at this point? Not seeing any. We'll have Judge Zone join us. Thank you, Judge, for sticking around.
Certainly. Good morning, Tom Zone, Chief Superior Judge. The first question, I'll pick up on what you were just discussing, and that is the potential impact on the courts. I'm unaware of any significant impact. In fact, I'm unaware of any cases that have addressed these issues since these statutes were first enacted in 2023. With respect to the draft under consideration today, on page 11, part of section 5, lines 1 and 2. That's a change in the existing language. It takes the language of judicial branch and judicial proceedings and makes it clearer for state court order or federal court order. And I think that clarifies and is an improvement. And so we would certainly support that. On page 13 in section 6, on line 14, starting on line 14, what this does is this says that if there is an order by a state, according to federal law, potentially by a state or federal court, that the order has to contain a certain language that says what it cannot be used for. I note that if it's a federal matter, a federal court may not follow, if it's a federal statute, a statute here about whether, what the order has to say. And so I just want to highlight that if there is a question about whether the state can tell a federal court how its orders have to be on federal law. On page 14.
So just before we go on, so that can apply to state courts, though, just to be clear that we are requesting that, or actually telling the court to include that in such an order?
Within constitutional limitations, of course. In other words, if there is a constitutional basis for a disclosure that comes to the court, for instance, if there's a criminal case and somehow the information is deemed that it is constitutionally accessible by a defendant, the court would certainly have to abide by the federal or state constitution. Outside of that, and we do that, for instance, with privileged information. There are cases and structures for addressing that. But beyond that, if the legislation sets forth and says, when a court is dealing with this exception, you have to include this for language, that's there, absent some type of constitutional protection.
Right. Okay.
On page 14, still in section 6, line 18, it says, a covered entity or business associate shall not be subject to any civil, criminal, or administrative liability or professional disciplinary action. I just want to note that could lead someone to believe that they are immune, both state and federal. And I don't know that the state has the authority to provide any type of federal immunity for those specific areas.
Right.
And in section 13, page 26, into the pharmacy section, on lines 3 through 8, it's the same issue. It says any liability. I'm sorry, it says shall be immune from. It doesn't say any, but it says civil administrative. It doesn't note that it's to state, and to the extent there's federal liability, I don't know that the state has the authority to change that. But those are the comments that I have.
Any questions for Judge Zone? Yeah, Barb.
So one question I have is, I know there's concern about if there would be more action in court if we pass this bill. If we don't pass this bill, this bill, do you see any impact on court activity?
I haven't
Like,
seen an impact on court activity from the bill that was
Right.
enacted in 2023. It's difficult certainly to predict what could happen in the future. But if we haven't had a lot of cases filed in 2 years, I would suspect that we're not going to see a significant rise. We certainly in the courts can absorb X number of cases. If we had 100 cases, well, certainly that would be difficult. If you have 3 to 5, 6 cases a year, I think that's something that very reasonably the courts can absorb.
Thank you. I just wanted to make sure. Thank you.
Any other questions for Judge Zone? Not seeing any. Thank you very much, Judge, and
you.
enjoy your new grandchild.
Thank you. Have a wonderful day.
Congratulations.
Thank you. Take care.
All right, we'll go to Jessa next.
Mark, can I ask a quick question?
Yeah.
Website.
Oh, yeah,
In the definitions, the first section, for B1.4. So looking at B1B, so that's the any act or omission undertaken to aid or encourage. So it's like kind of the sister to this one being act or omission in this state, I think. And this is or I don't know how to describe it. Basically, B and 4 seem fairly similar as far as the language. And I'm just wondering, in B1, big B, there's at the very end, a car, regardless of the patient's location. Is there a reason why that's not in 4 definition that's proposed?
Yes, that relates to telehealth, and in general telehealth practice, care occurs where the patient is physically located at the time care is provided, but for legally protected healthcare activity, Vermont has deemed it to apply regardless of where the patient is located, but not every state has done that. And so not wanting to put that level of reciprocity with another state that hasn't made that same extension, the language in the bill does not include that.
Okay, thank you.
Yep.
thank you. Let's move to Jessa. That's next.
Good morning. Hey, my first time in the committee. Thank you for having me this session. Jessa Barnard. I'm the executive director of the Vermont Medical Society. We represent physicians and PAs across the state of Vermont of all specialties, all types of practice locations and settings. We represent the individual clinicians active on this bill. We had several OBGYNs who testified, family medicine physicians. So our members feel very in support and grateful for the work of the legislature on this bill. We were very involved in supporting the passage of the initial, what we call the SHIELD bills in 2023, and see these as really important building blocks, especially based on what we are now learning in terms of actions being taken by other states, how other state SHIELD laws have worked, and what some gaps might be. So really, I would say overall, the goal of this bill as a whole is to fill some holes and gaps that we are now learning about from Acts 14 and 15 of 2023. I do want to, and I know, thank you to Legislative Council for bringing this up. I want to be really clear, and I think there were some good questions around what legally protected healthcare activity includes, and that it clearly excludes activity for which a provider would be liable under the laws of this state. So there was a lot of conversation around that, a lot of time and attention going into that when we were first passing Acts 14 and 15. How do we protect what we want to protect and make sure patients have access to care, but not feel like this is a shield against either unprofessional conduct or tortious medical care or anything like that. So that it was clearly not the intent. And I think the legislature did a really good job of defining that very precisely in Acts 14 and 15. We worked with a number of partners on the language in S28, so other healthcare organizations, the Department of Health, the Attorney General's Office, the Office of Professional Regulation, the Board of Medical Practice. There were a lot of witnesses that the Senate and House Healthcare Committees heard from, a lot of work put into the language. And again, as it's come out of the House Healthcare Committee report, we support all of the sections of the bill. I wasn't sure before this morning which section specifically you wanted to hear about, so I have submitted written testimony that actually talks about all of the sections of the bill, but I will focus more specifically on the sections you've mentioned this morning, just to give you a little bit of the rationale behind why we either asked for or supported various sections. Section 1 around the reciprocal protections. I think it is correct that no other state has passed legislation like this yet, but we do know there is work going on, especially among reproductive health providers, to look at whether could either be regional compacts or laws passed in other states to do exactly what Vermont is looking to do. So this is not a new concept. It's just it sort of has recently risen to the attention of providers. And so I would hope and expect to see similar provisions taking hold in the next year or so. And one example of why we're supporting this, there was actually some physicians here a couple of weeks ago speaking at a public event saying, for example, they are located in New York, they practice in New York, they provide telehealth services to patients all around the country, including in states that could put them at risk of civil or criminal prosecution. At this point, they feel very uncomfortable even traveling to Vermont and leaving New York without having reciprocal protections. That if they were facing liability or litigation in New York, they know New York's shield laws would protect them. They know their attorney general's been enforcing them. In fact, there's a pending case right now that New York has said we are protecting this physician. But if that happened and they were located outside of their state, what would happen? Can they travel at all? Can they visit family members? So the goal here is to say this was legal in New York. New York would protect you. Now you can still come visit your sister for the holidays here in Vermont. Vermont would protect you in to the extent that our laws also allow. Sections 5 and 6, the data protection, data sharing sections. BMS supports both of these sections. We see them working together. We see section 5 as the piece saying what are the limits on state entities expending resources to assist with interstate or to the extent possible federal investigations. And that really paired in our mind with section 6, which is about a healthcare provider's responsibility to protect patient information. So one, we're saying you providers protect patient information to the extent possible. And the other is saying, well, the state should also do the same thing, either for their own data or in terms of what resources they're expending to help facilitate other investigations. We worked really closely again with the Attorney General's Office, Department of Health, other provider organizations on the language in section 6. Most importantly, on some of the exceptions that would allow necessary data sharing for healthcare operations. So we heard, for example, from DEVA, which Vermont Medicaid, they operate as a healthcare insurer. There are some times when they do have to provide information to the federal government or other state Medicaid agencies. And we didn't want to say you can't share any data with any other state or federal government, because there are times when we really do for just the operations of healthcare. So the intent here, again, really is to get at targeted either investigations or actions that are really meant to either, penalize in some way an individual for seeking protected healthcare activity, not sort of at large healthcare operations. And I'm happy to stop at any time if there are questions, but I'll keep going. Otherwise, section 13, I think, is the next section you want to. Oh, yeah.
Are there questions on section 5 and 6 for Jessa?
I'm very grateful Legislative Council went before me. Hopefully they answered most of the tough questions, so I get the easy job.
I have a couple questions. They're not really relevant to a particular section, but just kind of your testimony thus far. You said a couple times our language. Were you one of the drafters of the bill?
We were not, we were a proponent of the legislation and testified in
Okay.
favor of specific
But you didn't
language.
provide specific language to the.
We did provide recommendations to
Okay.
the committee.
And then you made another comment about like a state compact and like regional compacts. Are you consulting with any other states at the moment?
No.
Would you speculate on which other states we might be in kind of a reciprocal agreement with?
I think, well, sure, because, and I know you already asked legislative council for this, but there are, please don't quote me on this. I would say in the, I don't know, 12 to 15, maybe, I don't know, 10 to 12 other states that have passed similar shield laws to Vermont. There was sort of a big flurry of activity around when Vermont was passing this legislation in 2023. So we are not the only state with fairly similar language. I would actually say, give some credit to Vermont. I think we came maybe second, third, fourth, somewhere in there. And I think we've improved upon some of the language that other states had adopted earlier. But in general, these concepts have been adopted by other states that probably wouldn't surprise you. States, New York, Massachusetts, California, Oregon, I believe. So those, obviously, it would be the states with a similar, I would say, a commitment to protecting access to these services that have passed shield laws that might have an interest in working together to extend them in a reciprocal way.
Thank you.
So the section 13 is the removing contact information from prescriptions. And I will say again, this is learning from actual actions that are happening so there is a physician in New York, Margaret Carpenter, this is all public, who is facing cases both from Texas and Louisiana after she prescribed abortion medication to patients located in those states. At least in one instance, it appears that her name was obtained from the prescription bottle that the patient had. And as prescribing medications for both abortion and gender affirming care become more politicized, more legally risky for both patients and prescribers, removing prescriber and pharmacist identifying information as it crosses state lines is one action Vermont can try to take to protect access to these medications. New York has recently passed similar legislation. There is one other, I believe it is Washington or Wisconsin. It is definitely a W state. I can get it to you if you want. That has somewhat similar legislation. It's a little different. And I think we're learning from New York. So New York's legislation, I believe, passed very quickly. And then in talking to the pharmacists here in Vermont, the New York language is what the language in this bill started as, which is don't include prescriber information on the bill. And it turns out, and you'll hear more from the pharmacists, that was really logistically unworkable. There was no way within their computer systems to have it not printed initially on a label. So we brainstormed with them and others about ways maybe this could how could they actually implement this? And so the stakeholders felt comfortable with redacting or removing a name from a prescription bottle. And we feel comfortable with where this landed, hope that it's actually, again, it may be improved. Maybe New York will need to now learn from us and modify their language. Apparently the pharmacists in New York don't know how they're going to implement it the way it was drafted there either. We do support, and then we also had conversations, again, you'll hear more from them directly, but about how will this request be communicated from the prescriber to the pharmacy? And that's really where the immunity language comes in. A lot of prescriptions are now transmitted electronically. Will it be immediately clear how to include this request? This is all by request of the prescriber. It may be in most instances, this is completely fine. If the patient is staying here in Vermont, there may be no risk. But if there is an instance where the prescriber wants to request this, it will need to be worked out and determined how that is communicated. In my mind, it's a little similar. Vermont has a law already about requiring substitution of generic medications for brand name. And unless the prescriber specifies otherwise, so there have been ways developed to either it's a checkbox in your electronic systems to add that little, do not substitute language on there. But as we're working out the actual mechanics of how this request will be transmitted, there's the concern, what if it doesn't get to the pharmacist? The prescriber thinks they put it on somewhere, but it didn't come across in the electronic system or wasn't seen. So again, a sort of a negligent lack of seeing the request as opposed to an intentional, I don't want to comply with this. I am not going to comply, but it's for some reason, this wasn't transmitted to me or I didn't see it type of mistake. So that's where we landed with or VMS felt comfortable with that approach to immunity in that section.
So I'm looking at the Dr. Maggie case. And it's interesting, right? So she was ordered, a mother of a pregnant minor in Louisiana ordered the abortion medication. Dr. Maggie knowingly supplied the medication. So I guess the question I'm kind of getting to, and this kind of gets to the immunity and the protections that are in section 13, is what happens when you start seeing, and again, like I don't know why Texas was introduced, but we can use Texas as the example here. In this case, it's actually Louisiana. What happens when we start having individuals doing these telehealth visits to doctors in Vermont, knowing that the medication or the services are illegal in the state from which they're requesting them from? And all of a sudden we have this immunity protection of people providing the stuff that is knowingly illegal in the state from which they're requesting them.
Yeah, I think I have two answers, which is one that is actually one of the intents of the Shield Law, actually, is to allow legal activity in Vermont to be able to be extended to patients located elsewhere if the prescriber is located here. So that is actually a intent of the original, not changes in this bill, but the original Acts 14 and 15 of 2023. In fact, this committee talked about, heard about that bill and talked about some of the telehealth provisions and a lot of conversation around where do you need to be licensed, who are we protecting, in what instances. So the example of a New York physician prescribing to a patient in a state where it is in that state not legal, but it is legal where the prescriber is located, what is an intent of what the Shield Law can allow or protect against. I would say nothing in S28 changes any of that except the name being on the prescription bottle. That is really the only change, and liability for a mistaken failure to redact the name. That is the only change that this makes in that scenario.
So I appreciate that. And so I guess to put a finer point on it, the goal of this is not only just to enable this behavior, but to encourage it.
I would say to protect it.
Thank you. I just want to make sure that we have that on the record.
Right, and it's up to individual doctors and prescribers in Vermont on whether they want to do telehealth or not.
Absolutely. And there's a lot of risk to still doing. I mean, those doctors are getting some protection, hopefully, from their states, like in New York and Vermont. There's still a lot of risk. They don't travel out of state. That's why we're talking about these reciprocal protections. They certainly don't travel to the states where it is not legal and where they don't have shield laws. They're still taking on a lot of known unknowns in terms of how protective these shield laws will be. Will they hold up if challenged? So it is not without risk, and it is completely voluntary. And I would say the vast majority of providers in Vermont are not using the shield laws for that reason. They are trying, and we're not talking about a lot of other sections in even S28, which are really aimed at our Vermont located providers caring for Vermont located patients. And that is really, I mean, and as an organization representing Vermont clinicians, that's really my priority. And that's really the bulk of what both the original and changes in the law do. We're just talking today about some provisions that are more for interstate purposes.
So then we ask the other question, the Louisiana case, what is the status of that case? And is there a path through that or other cases you know of that may be challenging the concept, the basic concept of the telehealth?
I think they are both, and I haven't looked in the past couple of weeks, both quite preliminary. New York's governor, I believe, or attorney general, or both have said they are going to defend her using their shield laws. But I think it's still very early. I think the facts are still very unknown. I know in one of the instances, there is a complicated parent-child scenario, but I think the facts are quite debated about who knew what and when. So it is a test case, I would say, of how effective shield laws can be.
And I would add too, Chair, that Governor Hochul declined to extradite Dr. Maggie to Louisiana at Governor Landry's request.
Right.
Correct.
Yeah. Yes.
Which is another piece, again, that was in the underlying shield laws that Vermont also would do the same.
Exactly.
Have you considered extradition pieces? Yes.
We have not considered changes. Again, those are in the underlying, original language. So we haven't looked at whether that needs any, we are not aware of any changes at this point that would need to be made to that.
I'm trying to think jurisdictionally and Vermont sovereignty in this, with its law. If the doctor here does something and it's not against the law here, and they put it in the mail, if they're allowed to do that here, they broke the law. If they didn't break any federal law with that package landing where it went, foul until something happens there. Does Louisiana have a law that says it's illegal for it to be sent there? Is that what it is? Or using it there?
I think it is the provision of it there. I'm not sure if it was I don't know if it was the mailing or the prescribing of, but that's exactly, you're right. I mean, you've hit on exactly the facts of the Louisiana case. So it was a Louisiana law being trying to be enforced against a physician located in New York.
Jurisdiction over that doctor in this state, the way we're.
That is the challenge.
So we're just worried about that doctor passing through Louisiana, getting pulled over and being arrested for something if they're named in an indictment in Louisiana.
I think, yes.
But there has to be some law there that would make them some sort of jeopardy.
Correct.
I'm just curious, is that what's
Correct.
happening?
Yes. And then the question of whether, right, do they have jurisdiction at all over the physician who's never been located there, or or I think explicitly trying to challenge New York's shield law of, does New York have to comply with any order in this case?
Okay, other questions? Yeah,
I didn't know if this pertains or not. So I'm gonna assume that there's some drugs or medications that may be legal in one state and not legal in another?
There are some I don't think that has actually happened yet, that the drugs themselves are legal or illegal. It is the service. It is, say, abortion after a certain gestation, or abortion at all, or so it is or in some states where medication for gender affirming care service, or providing any services for gender affirming care. So it's not necessarily that the state has made medications illegal. It's actually medical services that they are making illegal.
Cause I was just thinking somebody that got a prescription here that went to another state.
Possessing that medication alone probably would, I don't even know, I think would not be illegal, but it would be the purpose for which you are taking it, which is actually what makes some things like legislating gender affirming care very complicated, because there are many non-gender affirming care reasons you may be taking testosterone or estrogen or other hormones. And so, then it's really the state getting into questioning why a patient is taking a certain medication that's used for a lot of purposes.
Since you brought that up, I was gonna wait and ask Lauren, but maybe you can answer the question. Aromatase inhibitors or hormones, are they a scheduled drug?
Testosterone is, but others are not. I believe of the world of medications we are typically talking about for both gender affirming care and reproductive health services, which, remember, is not just abortion, but contraception.
Right.
And other, I believe testosterone is the only controlled substance on that we're talking about.
So that when
the removal of the name of the prescriber or pharmacist would not apply to testosterone.
What about estrogen?
Is not a controlled substance.
What testosterone is?
interesting.
And risk of misuse is often what flips things from one schedule to another.
Other questions for Jessa? I don't see. So just a time check on this. Lauren, would you be available this afternoon? Because we're going to still need some more discussion this afternoon. Is that, I would say around 2:00-ish?
Let me let me take a look at my schedule real quick. If memory serves, I have a fairly packed afternoon, but let me see if there's any flexibility in that.
Otherwise, we can just plug through a little bit, and we will need to talk about whether there's any amendments and just kind of take stock of where we are. So Daisy, I think you'll be asking for presumably a request for an extension, by one legislative day, just to give us some more time.
Thank you very much for your time.
Thank you very much. Thank you.
I have a little bit of flexibility. But if there's an opportunity to at least begin the discussion now,
Sure.
that would be convenient for
Is that
me.
good with you?
Otherwise,
Yeah, let's go ahead. Let's go ahead. We'll.
So my name is Lauren Bodie. I'm the legislative liaison for the Vermont Pharmacists Association. And thank you for the opportunity to come in and provide some testimony today. So I'll piggyback on kind of what Jessa had said, and that, overall, like the stance of the Vermont Pharmacists Association is that we understand the reasons, behind this bill, and are in favor of supporting our prescribing colleagues. Implementation is going to be really tricky. And so the germane section 13, is really about concerns around that implementation. And this is because over the last 50 years, pharmacy, like the rest of the medical field, has embraced standardization as a core tenet towards protecting patient safety. And so when we got down to talking about what implementation of this bill would look like, really this is going to require individual action on the part of the dispensing pharmacist to step outside of that standardization to be able to physically remove the prescriber or dispenser name from the label. So at any time we're asking someone in any field, whether we're any high risk field, or we're talking about aviation or medical care or what have you, we're introducing the opportunity for there to be a miscommunication or a misstep, not necessarily through the fault of that individual person, but just by asking them to work in a way to which the system is just really not set up to permit. And so for that reason, since we are talking about kind of the physical removal of a name from a prescription label, that, theoretically, this is an action that could be taken by the patient, it could be taken by the prescriber themselves, rather than shifting the entirety of that liability to that dispensing pharmacist. We are instead asking if we're sharing that liability, to also share in that protection. And so that is the reason for the request for that pharmacist or pharmacy technician, any pharmacy person who is acting in good faith to comply with the law, but that understanding the limitations of the systems that person is going to be operating in, if they miss the communication, or it doesn't get carried forward to a refill, for example, that they're offered protection from basically legal action. This is not saying that if someone is intentionally not complying, that's a different scenario, and they would be eligible, able to be to have disciplinary action taken against them. But for those operating in good faith, we ask for that protection, so that there's not undue penalization, undue penalty, I should say, for that pharmacist when they are trying to comply. And given there's constraints of time, I'll pause there, but certainly invite questions.
So what is the disciplinary action that you're referring to if they don't manage to remove the name of the doctor or dispenser?
So whether that's a lawsuit brought by the prescriber, or whether that's actions brought by, say, the Board of Pharmacy, or those would be the two things that come to mind. But just basically looking for protection in just things that could have financial or professional consequences when this was a pharmacist trying to do their best to comply.
Right. So I guess that the part that jumps out at me is just not seeming to fit is criminal liability. I don't see any possible crime we're not creating a crime. We're not creating an obligation to do this in here with a criminal penalty if it's not removed. So that I don't think makes any sense. I can understand that we're narrowly, or should be narrowly, protecting negligence by a pharmacist. And I think we should probably make that clear. I don't know if that will help you, Zach, on that or not, but I think that clarifying the narrowness of what we're really talking about.
Yeah, our understanding is that this is applying, specifically to Vermont law, and specifically actions like taken in Vermont, whether that's by a prescriber, by a I guess, and so this is where when we're starting to talk about the difference between like civil and criminal, where it's like I'm highly conversant on, say, the difference between an ACE and an ARB for blood pressure medication. I would not consider myself highly conversant of the ins and outs of different segments of our law.
Right, because I'm just trying to understand what the action could be if somebody fails by negligence to take off the doctor's name, for instance. I mean, it would seem that if the doctor subsequently gets in trouble for prescribing, that somehow they could bring in the pharmacist. That I don't know how well that lawsuit would work, frankly. Or the doctor would sue the pharmacist for doing that. I'm not sure. He have to show, or she would have to show some damages. I'm just trying to understand the scope of what this law requiring the removal of those names. What's the scope of what kind of liability that could arise? And that seems to be fairly narrow to me, unless I'm missing something.
No, the scenarios you're describing are, what we had articulated as concerns. And I'll say, we were not involved in drafting the language. We were able to engage in some conversation expressing, some of the foreseen potentially unintended consequences that we were concerned about. But then, deferring to legislative counsel who actually drafted in response to those like stated concerns.
And then Zach.
Hi there. All things aside, I know it's very important in your business to follow set procedures generally. Does it cause you or your colleagues any pause whatsoever stepping outside of the normal practice?
Pause, not only in, I would say only in terms of, we implement systems for a reason. I would say when I speak to people about this, I'm not hearing concerns about legality, because I believe you've heard from the Board of Pharmacy that the plan is that they would adjust rules in accordance with this bill to make it legal. And so, outside of that, really the only concern I've heard from people is, how are we going to do this? How are we going to do this consistently? How are we going to do this appropriately? How are we going to do this without complicating our workflow? Because in addition to this sort of one instance, we also have a queue of other prescriptions and patients that we're actively like caring for within that set amount of time. So I'm not hearing concerns other than, okay, how do we make this work? and that's where we get it. And because we weren't coming to very good answers of like, oh yeah, this is definitely how we're going to make this work. That's where it's like, okay, how do we make sure that we're not like leaving ourselves exposed when maybe some of these systems or processes don't work smoothly. And so that's the intent, nothing beyond that.
Oh, no, Tom.
Could it be something as simple as you hand them the medication and they say, "Oh, you didn't black this out. Well, here's a Sharpie."
Well, I mean, no kidding. I think that's what we're talking about. We're talking about cutting off a prescription label or redacting with an indelible marker.
To further that, I mean, you could also just let them do it on their own and then you're just off the hook.
Well, not with the bill as written. And so that's what we're talking about with the idea of like, if pharmacists are going to be sharing in the responsibility of, doing this redaction, then we're just also asking for protection as we are implementing that.
Thank you. So Lauren, I hear the concerns on implementation. I'm wondering if there has been any thought given by your member pharmacists on interstate travel and concerns there.
Could you clarify more what you mean?
Like, are you afraid to travel to Texas, Louisiana, Florida, any state that might not recognize the shield laws?
I am not at this point, but I think this is where, the differences between prescribing and dispensing at this point has, we're seeing prescribers targeted so far. I don't know what the future is going to hold on that. But our goal at this point is to protect our patients, protect our prescriber colleagues, and comply with Vermont law.
Yeah, no, I get that. I guess the thing that I'm concerned for all of you is once the genie is out of the bottle or out of the lamp in this instance, and you guys, you want to travel to Houston or Dallas or New Orleans for Mardi Gras or Miami or Palm Beach, I just, it starts raising some real questions and concerns, like if your association understands like what the implications might be. And I don't think that there's going to be a retroactive relitigation of this. And the consequences could be, very severe and ultimate, you know what I mean? So like, I'm just thinking worst case scenario for all of you and the protections there. And I just want to make sure that we know exactly what we're getting ourselves into because the federal government is going to be all over this. They already are.
Well, and this is where I'm going to have to, say again, I'm very good at managing your diabetes. I'm not good at providing legal counsel.
Yeah. Yeah, but I'm just saying, I hope everyone in the room understands like what we're doing here too. So thank you for your testimony.
So a couple of questions for you. And maybe this is for Jessa as well. Does a pharmacist have to prescribe? I mean, if they get a prescription that's sending something to Florida, I'll pick on a different state. Does the pharmacist have to do that? I mean, my understanding when we took this up last biennium was pharmacists could refuse to participate in that. Is that not correct? I guess I'll ask Lauren first.
So are you meaning sort of the idea if like the individual pharmacist has a like an ethical or moral objection to the kind of care that's being prescribed, or
could be that, or just doesn't want to take a chance, wants to make sure they can travel to Florida. Is it voluntary as far as if you're sending medication to one of these states that ban that?
That's a good question that I'm not sure that I have a good answer to. I can comment in terms of what are, sort of unifying like professional ethical standards around, providing like prompt care. There is, of course, a difference between law and ethics. In some cases, I am not aware of any issues with saying, I have not heard personally of any cases of a pharmacist refusing to dispense across state lines because of this. Now, because of, potential actions that they're worried could be taken. Now, I will say that this is perhaps not germane to this bill only because this is only pertaining to prescriptions dispensed in Vermont. And so this would only pertain to medication that is being dispensed to a patient in Vermont from a Vermont pharmacy. Because that is what is regulated by the Vermont Board of Pharmacy. If a pharmacy that is, for example, mailing medications to another state, they are governed by the laws of that state if they're dispensing the medication directly to that state. And so for the purposes of this bill, this is only going to pertain to Vermont pharmacies dispensing to Vermont.
Okay, well, that's very helpful.
Yeah.
So the other question I had is, I mean, I heard that there's concerns, but is the association in favor of this bill? I didn't hear if you're supporting the bill or neutral or opposed or.
No, we're generally supportive. In more from the standpoint of, you know, we like our, you know, physician and other like provider colleagues, you know, we believe it's important to take care of patients and that providing reproductive care and providing gender affirming care is a part of taking care of patients. And so our concern, if any concern has been expressed, has only been on how are we going to implement this. I do not hear concern from people practicing that they have concerns outside of that.
Andrew?
I think that answered my question. Just wondering generally, what I wanted to check, my understanding from what I'm hearing from you is that, though the question is, how are we going to do this? It's not, are we going to do this? It's more about implementation and leaving room for, I guess, what I would call figuring it out. Is that accurate?
I think that is reasonably accurate, and I think more figuring it out and to not allow the liability to fall on pharmacists who are trying to figure it out unduly. That as we are like collaborating with others to help provide protections for them, that also we are given some protections, you know, against that, like potential civil action if it is done in error.
Any other questions for Lauren? It looks like we don't need you back then, I don't think, this afternoon. So for the rest of the committee, like right after the floor, 15 minutes after the floor, we'll take this up again and have a discussion of kind of where we are. I feel that there are some tweaks, at least in the language. I know that some folks are, no matter how I tweak it, are not going to vote for this, but I just want to know whether people are ready to vote as well, and we can come back and talk. And I know that if hopefully Michelle and or Jen can be here, or one or the other to hear. And I know that, Michelle, you have a couple things that you're trying to track down for Zach, if that's at all possible to get that. So anything else for now? All right, thank you, everybody. I thank you very much for the